Well, good morning, everyone, and welcome to the second part of our two-part webinar series discussing two significant pieces of legislation which have come into force in 2022. I am Iain Drummond, a partner specialising in construction and engineering dispute resolution, and I'm joined by my colleague this morning, Chiara Pieri, who's a solicitor in our team. Our team regularly advise on construction contract issues and disputes across a range of projects and clients. So we therefore have a great deal of experience in litigation, arbitration, adjudication and mediation, where our arguments have to reflect ever-evolving judicial approaches to construction law. Now, in last week's webinar, we looked at the development of the law of prescription, which is time bar on claims in Scotland, with particular focus on the Prescription Scotland Act 2018. But today's webinar will look at the changes brought about by the Building Safety Act 2022, which has recently come into force and which applies mainly to England and Wales, but also to Scotland in certain respects. So in this webinar, we will examine how the new Act has developed and what these changes might mean for your construction businesses in 2022 and beyond. If you'd like to ask a question during the webinar, then please do so by using the Q&A button. And in order to keep within time, we will answer as many questions as we can at the end of the webinar. But if we don't manage to get to your question, or if you are listening to a recording of this webinar, we'd be very happy to address any queries that you have after the webinar by telephone or by email. And our contact details are noted on the next slide, so you can use those for that purpose. So I will now pass you over to Chiara, who will run through the agenda for this morning's webinar.
Thanks, Iain. So we'll start today by introducing the background to the Building Safety Act 2022 and the aims of the Act. We'll then go through some of the main changes that that Act introduces. Firstly, we'll discuss the roles and responsibilities of the new Building Safety Regulator, describing the likely interactions construction companies will have with them. We'll then identify the relevant duty holders during the life cycle of a building construction and what duties they're likely to have under the 2022 and future regulations. After that, we will look at the distinct regime which has been established for higher risk buildings, explaining what safety checks and information communication are required at each stage of construction. We'll then finish by explaining the changes around liability for remedial works and the new extended limitation time bar periods that will apply for breaches of building rules and standards. So the Building Safety Act 2022 came about following the Grenfell Tower fire in June 2017 and really reflected concern amongst politicians and the general public about building safety standards in the UK, in particular fire safety in high-rise buildings. After much debate and many amendments in Parliament, the Building Safety Bill was enacted in April 2022 with far-reaching consequences for the construction industry. Although it is hoped that the Building Safety Act 2022 will secure the better safety of building residents and the wider public, it will mean significant changes for practices and responsibilities and even potential liabilities in the construction sector. This webinar will explore the specific changes created by the 2022 Act. In brief, its primary purpose is securing the safety of people in and around buildings. Although some of the Act's provisions are now in force, much of it will be implemented through future secondary legislation, which we can expect by the end of 2023. It should be noted at the outset that the practical effect of the 2022 Act is limited to England and Wales. However, there are some important provisions that will apply in Scotland, including the new Home Ombudsman scheme and extended prescription periods for defective construction or cladding product claims. Aside from these exceptions, Scotland will largely follow its own regime. So today we'll probably be looking more at the changes as they apply to England and Wales. And also, given that the 2022 Act is long and complex and it has changed significantly during its passage into law, this webinar will focus on the sections that will have the greatest impact on the construction industry. It's not intended to be comprehensive. However, if you have any specific questions, then as Iain said, please do either ask in the Q&A chat during the seminar or our speakers afterwards. So the 2022 Act provides a distinct regime for buildings it classifies as higher risk. What is a higher risk building? Well, Section 65 provides two criteria. The building must be firstly 18 metres in height or 7 stories high or more, and contain at least 2 residential units. Section 65(2) allows the Secretary of State to designate more criteria, definitions and exemptions. This is an evolving area, and it is likely that these definitions will change. There were suggestions in Parliament that 11 metres was a more appropriate height due to fire rescue service ladder lengths. Also, the Building Safety Regulator can recommend additions or changes to statutory definitions, for example, the inclusion of single-storey buildings at high flood risk. Ultimately, any redefinitions by the Secretary of State must receive parliamentary approval under Section 168, but we can expect changes over time which may encompass a wider range of buildings where people sleep and a lower height threshold, so it is worth keeping up to date with this. The Act essentially creates new roles and responsibilities to ensure greater competence and accountability throughout the entire life cycle of a building in its planning, construction and occupation. The first of these roles is the Building Safety Regulator. Under Section 3 of the Act, this statutory responsibility has been given to the Health and Safety Executive. The Building Safety Regulator's job will be to drive improvements in standards in the industry and ensure consistency of competence among professionals for all buildings across the country. This will include regulatory oversight of all other building control bodies and approvers. The degree of involvement construction firms will have with the regulator will depend on whether the buildings they are constructing are classified as higher risk according to the Act under Section 4. However, the regulator is also afforded powers to secure compliance with safety standards. For example, Section 24 of the 2022 Act creates criminal offences for providing false or misleading information to the regulator with a possible unlimited fine or even 2 years imprisonment. The regulator is also empowered to compel developers to correct works which do not comply with building safety regulations, known as Section 36 notices under the Building Act 1984. In short, the regulator has teeth legally to bring about compliance with new safety standards, and regulators' powers of intervention could cause delay to projects. Those in the construction industry will therefore want to achieve a collaborative relationship with the Building Safety Regulator, ensuring proper compliance with standards and providing the regulator with all of the information required by the Act. Currently, the regulator is conducting a consultation on cost recovery for performance of its statutory functions and is inviting responses from the industry. Responses must be submitted by the 7th of October. This is because under the Act, regulations can be made to allow the regulator to charge fees and recover charges for or in connection with carrying out its relevant functions. Understandably, those in the industry want to understand what the regulator's chargeable activities will be, the trigger for those activities, who is required to pay, and how that amount will be calculated. As I understand it, under the consultation in total, there's currently 23 proposed schedules of charges, and charges range from a fee for the submission and consideration of a building control application, where the regulator assesses the application, whether it's in accordance with the building regulations, to receipt of a change control application during the design and construction phase, and whether to accept or reject that application. It also proposes charging for the consideration of a completion certificate application and for the regulator becoming aware of potential building safety risks. In many cases, the fees will be for the cost of an application and/or a charge for the hours worked by regulator staff, plus costs of relevant authorities and third parties, and will be generally charged to the client or applicant. Precise amounts for the fees and charges have not yet been set. One of the aims of the 2022 Act is to identify those accountable for building safety on a project so that the key actors are known when problems arise. The guiding principle is that those who create the risks should bear the responsibility. The Act gives the government powers to introduce, via secondary legislation, requirements for these actors known as duty holders. And the duty holders are as previously set out in the Construction Design and Management Regulations 2015, which, as you'll see on screen, are the client, principal designer, principal contractor, designer and contractor. And duty holders will need to cooperate and communicate through the whole building process so that their responsibilities are not simply a box ticking exercise. Future regulations will set the level of duty that will be imposed on duty holders. This was expected to be to ensure compliance as far as reasonably practicable, but this is now expected to be more onerous. At the same time, the British Standards Institute is also developing standards for the industry, and in July 2022, BSI published specific competence requirements for various duty holders and operational safety practices. This is an evolving area, so it would be prudent to pay attention to any ongoing developments. A core priority of the 2022 Act was implementing higher safety and competence standards throughout the whole process of construction. And one of the main ways that it strives to achieve this is through the so-called gateway regime. This will be introduced through secondary legislation with powers stemming from the amended Building Act 1984. There are three distinct stages or gateways which have been set for the construction life cycle of higher risk buildings, with specific duties and approvals needed under each gateway. The gateway one is the planning stage, which is expected to involve a consultation with the health and safety executive before planning permission for a higher risk building is granted. Planning applications are to include a fire statement where potential dangers and issues have been considered, and the planning authority should take into account the needs of the local community. Gateway 2 is the pre-construction stage, where the duty holder is expected to provide the building safety regulator with the full design intentions. And the idea is to implement a hard stop where construction cannot actually proceed until the regulator is satisfied that the design complies with the building regulations and contains no unrealistic safety management expectations. Practically, the designers will have to show how their proposals comply with the regulations, with particular justifications around fire and structural safety. Gateway 3 is the building completion stage, which occurs at the final certificate phase when the relevant building control body determines whether the structure has been built in accordance with the regulations. All prescribed information and documents are handed to the building owner and the regulator, and when the regulator is satisfied, they will provide a completion certificate and register the building on their systems. The documents mentioned here are known as the golden thread, which Iain will come on to. And Gateway 3 is also a hard stop stage, so the regulator will conduct final inspections. So occupation of the building is only permissible once A, all of the gateways have been cleared, and B, that the building is properly registered. As with much of the 2022 Act, changes are still on their way. In fact, consultation on the gateway regime and how it will work is ongoing. It opened in July 2022 and closes the 12th of October 2022, so further details are likely to emerge shortly. I'll now pass over to Iain.
Thank you, Chiara. So the golden thread of information was a phrase coined by the Hackett Review to describe the standard of disclosure that should be required for higher risk buildings. And it's about having a thorough, substantial and accurate set of evidence for safety arrangements. Now, according to the report, the government plans to bring in golden thread regulations specifying principles for the accountable person and duty holders to follow. And although specific information on this is presently limited, property developers are being urged to cater to golden thresholds immediately. So for example, in December 2021, the HSE advised designers to record evidence of decision-making during the entire design process and to maintain engagement throughout the whole building life cycle. As with gateways, consultation on the golden thread continues until 12th October 2022. In order to improve ongoing assurance of the safety of occupied high-risk buildings, the 2022 Act allocates one or more accountable persons. Now, these accountable persons will each be a recipient of the golden thread so that they can understand the potential dangers and issues in the building. And given the complexity of building ownership in the UK, designating a principal accountable person increases the likelihood that safety risks and defects are resolved promptly through that person. Whereas under previous laws, there was no specific person required to have overall responsibility for the whole safety aspects of a building, and that was an issue identified arising from the Grenfell tragedy. So who are the accountable persons? Well, generally, this will be the organization or person who owns or has responsibility for the building. Since there may be more than one accountable person in any one building, the Act appoints a principal accountable person who will be responsible for fulfilling statutory duties for the entire building. And according to Section 75 of the Act, where a principal accountable person has not been registered with the building safety regulator for a particular building, or where no such person can be identified, an application may be made to the first tier tribunal for an appropriate person to be appointed. The accountable person's obligations are included in Part 4 of the 2022 Act, which provides a long list. But briefly, these duties include statutory duties to register the building prior to occupation, then apply for the building assessment certificate, and to proactively manage and assess building safety risks through a safety case report, which they will be required to keep up to date and then submit to the building safety regulator. According to the HSE, the principal accountable person must register existing buildings between April and October 2023, while new buildings must be registered prior to occupation. A common criticism of the Building Safety Bill as it progressed through Parliament was its lack of adequate protections to leaseholders from having to pay for remedial works. And they developed a strong political focus on this, given that leaseholders are not usually at fault for building defects, particularly cladding issues. Under sections 116 to 125 and Schedule 8 of the 2022 Act, there is now a scheme for who is considered liable to pay for rectifying building safety defects. And the scheme is clear that these costs should not fall on leaseholders. So in the first place, it sets out that the constructing developers and manufacturers will be liable, and failing that, the building owner is to look to government funding. Where there can be no recovery from either of these sources, the costs will remain with the building owner, including obligations to refund service charge overpayments from leaseholders. For non-cladding related fire safety defects, it may be possible to ask leaseholders to contribute, but this is restricted. The amount chargeable is capped, and it's only an option where the building's landlords are collectively worth less than £2 million. So the construction industry will no doubt be concerned as to their liability for remedial works, and there is ongoing uncertainty here at present. The government's original plan was to obtain agreement from developers and manufacturers to undertake remedial works through a building safety pledge, and that was led by Michael Gove, as you may recall. However, some but not all developers have agreed to the pledge. So there is a chance that for where there isn't agreement, the government will resort to compelling compliance under the Building Safety Act, which is permitted to do by Section 126. Similarly, the first tier tribunal has powers to mandate repair works through remediation contribution orders. So there is a strong likelihood of developers and manufacturers having to bear the brunt of any remedial works, especially given the changes the 2022 Act makes to limitation periods, which I'll now come on to. So in last week's webinar, we looked at the laws around prescription, which is legal time bar in Scotland. And the main idea is that after a set passage of time, a party who suffered a loss will no longer for public policy reasons, be able to bring their claim to court. And in England and Wales, this is known as limitation. The standard limitation period for legal claims in England and Wales is 6 years, but the Building Safety Act 2022 introduces significant exceptions to this with extended limitation periods. And it introduces these longer limitation periods for claims under the following categories. So firstly, under the Defective Premises Act 1972. Secondly, for breaches of construction products regulations by manufacturers. And thirdly, under Section 38 of the Building Act 1984. Now, all of these changes are in force from 28th of June 2022, except the third one, and that's in relation to Section 38 of the Building Act 1984, which is not yet in force. So looking at these more closely then, firstly, the Defective Premises Act. Section 1 of the 1972 Act establishes an obligation to conduct building work on new dwellings in a professional manner with proper materials in order that the completed dwelling is fit for habitation. This duty under the 1972 Act applies to those involved in the original construction of the dwelling, be it a house, flat, or otherwise. However, the Building Safety Act extends this liability to anyone who does relevant work on a dwelling, even after its original completion. So in short, the Defective Premises Act 1972 now applies to work on existing dwellings as well as new ones. Also, the Building Safety Act extends the limitation periods for claims under the 1972 Act, and it does so in two ways. Firstly, for substandard workmanship that leads to a dwelling being uninhabitable, from June 2022 onwards, the limitation period for raising a claim against the developer will now be 15 years rather than the previous 6 years. And secondly, residents of uninhabitable dwellings caused by poor workmanship can also now claim for historic breaches, which would up until now have been time barred. So in effect, these past claims are revived. And for breaches that occurred before June 2022, the limitation period is now 30 years. And actually in practice, that's 31 years because of a particular quirk. But the effect of this is that developers may find themselves in court for construction work dating from 1991 to 1992. Clearly, this extension backwards was controversial, and the government did concede two qualifications in the Act as it was eventually put onto the statute books. So firstly, a retroactive claim cannot be one that infringes the defendant's human rights. And secondly, a claim that had previously been dismissed or settled cannot be revived. And of course, it does remain to be seen how these two qualifications will be applied by the courts. So the second category then is in respect of construction product manufacturers. The Building Safety Act creates a new liability for dwellings similar to that under the Defective Premises Act 1972, but now targeted at construction product manufacturers. And again, this specifically arises from the Grenfell tragedy circumstances. So according to Section 148 of the 2022 Act, where manufacturers have supplied builders with defective or substandard products, and these cause or contribute to the dwelling being uninhabitable, the manufacturers become liable to pay damages for injury, property damage, or economic loss. And although these Section 148 breaches are prospective, that is applicable after June 2022, they do have a limitation of 15 years. But where the claim relates to defective cladding products, it can be retrospective with a 30-year limitation period. Finally, in respect of the Building Act 1984, this part, Section 38, has not yet been brought into force, but when it does come into force, this will be a wide-ranging provision which will allow any individual to raise an action for damages where they have suffered injury or damage caused by a building which has fallen short of building regulation standards. And this will apply to all buildings in England. When it comes into force, the limitation period will be extended from 6 years to 15, but it will only apply prospectively. Now, An issue debated during the passage of the Building Safety Bill was, what if the original developer was to seek to set up corporate structures like shell companies to avoid liability for the new regime imposing liability for building defects? Well, as noted earlier, a key aim of this Act, the 2022 Act, was to make those responsible for building risks pay for them. So now sections 130 to 132 of the 2022 Act, they now allow the High Court to issue building liability orders, which can ascribe liability to an associated body in circumstances that are, quotes, just and equitable, close quotes. So in practice, this will mean examining which corporate body in reality had control during original construction, and that will be regardless of whether the original developer has since been dissolved. So this is intended to prevent developers avoiding the new liabilities by setting up shell companies or other avoidance devices. So overall, it's clear that the Building Safety Act 2022 will have significant implications for the construction industry. And whilst the new regimes introduced by this Act are still evolving, and more changes are expected in the coming years through secondary legislation, how should construction businesses, particularly in England and Wales, start to respond? Well, firstly, all those involved in construction, whether in planning, design, product manufacturing and building, should set up robust systems of information retention and communication. The gateway regulations will require safety checks to be conducted thoroughly and recorded in a detailed and accessible format. And compliance with the new regime will not only be something to be performed, but demonstrated through evidence, and that is a clear focus of the new regime. You should also ensure that such information is passed on to the correct regulatory agencies and duty holders, so that the golden thread runs through the whole project from the initial planning application to final occupation. By setting up these systems promptly, this will help to avoid potential costly future litigation and penalties, and also reputational damage, which could result from breaches. Secondly, become familiar with the duties and roles of duty holders in the life cycle of construction projects. This is particularly relevant where there are several subcontractors or novations of contracts, when responsibility for particular duties and checks may not immediately be clear. It is important to know at all times who the accountable parties are, for instance, the principal designer and construction product manufacturer, so that there is no ambiguity around who is supposed to possess which information and when. Thirdly, specification of who will undertake the new statutory duties will form part of the negotiations with stakeholder parties. And of particular importance will be some of the following areas. For instance, any exclusions or carve-outs from consultants' responsibilities, for example, for fire or cladding related matters. In these cases, it would be prudent to include warranties that the consultants will not offer advice on these excluded areas. Also, given the expected removal of the reasonable skill and care limitation from the standard of workmanship under CDM 2015, ensure that relevant contractual clauses are not applying a lower threshold for duty of care. Also, avoid or look to avoid caps and net contribution clauses in appointments and supply chain agreements, which could affect the ability to recover from parties who have contributed to the relevant loss. If insurers do insist on such caps, then be sure to seek a carve-out for liabilities arising from breaches of the Defective Premises Act 1972 and the Building Act 1984 in particular. Finally, act to preserve key evidence in response to the changes in limitation periods, both prospective and retrospective. Given that 30-year-old claims could soon resurface, developers should avoid destroying and try to collate potentially relevant material. So this could include old documents, photographs, and witness statements, and also correspondence. In some cases, clearly, through passage of time, these may no longer be accessible, but it is important to establish systems whereby such evidence is henceforth stored robustly and reliably so that it can be accessed and used for a defence in due course, potentially after a significant passage of time. So it's very important to now review internal document retention policies and practices so that evidence preservation is paramount. So that concludes our presentation. We have got time for one question just before we close proceedings. So Chiara, I think there's one question you could perhaps deal with briefly. One is, it is that we've been asked a question, can one contract out of the new limitation periods which are created by the Building Safety Act 2022?
No, unfortunately not. They are statutory limitation periods have obviously been set by the Act, so parties will not be able to contract out of those periods.
Okay, thank you. And we have probably time just for a quick second question, which is, what parts of the Act apply in Scotland? I think I can probably answer that. We touched on this at the beginning of the presentation, but mainly it's the new rights of action and extended liability periods for construction and cladding products that apply in Scotland. But secondly, the establishment of the Homes Ombudsman scheme applies to Scotland, and that's the new forum for complaints against members of the scheme, which would be investigated by the independent ombudsman. There's also aspects of new aspects of the regulation of architects, which we haven't touched on, but those will apply in Scotland. But these are really the three principal areas. Otherwise, the practical aspects and the changes that we've been talking about today really just apply in England and Wales. So that's, we've gone just slightly over time, so we'll bring proceedings to a close now. So just remains for me to say thanks very much to all of you who've listened in. I hope you found this useful. We will endeavour to respond to the questions that you've typed up in the chat box, and any questions that occur to you after this webinar, please do get in touch with Chiara and me through our contact details, and we'll come back to you as soon as possible. So thanks very much for joining us, and we hope to see you again soon.
Thank you.